Hello, my name is Esther Ann. I work at the Cutler Institute at the University of Southern Maine with the Capacity Building Center for Tribes. I am a Pescamukudi, Passamaquoddy tribal member from here in Maine. Happy to be here. So today, this is the first in a series of 3 webinars that we are offering around ICWA compliance. As a federal law, you all know, I'm sure, that ICWA requires states and courts to work to protect the best interest of Indian children by keeping their connections to family, community, and culture intact. Compliance is mandatory, but we know that many state child welfare and court systems continue to struggle to consistently and effectively meet these requirements. With a strong understanding of the rights and responsibilities of ICWA, tribal leaders and tribal child welfare ensure, excuse me, with a strong understanding of the rights and responsibilities of ICWA, tribal leaders and child welfare professionals can help improve collaborations, ensure compliance, and better protect their communities. So we're real happy today to be talking about and learning more about the findings from the ICWA Baseline Measures Report, which focused on building the capacity of court improvement programs to measure the application of ICWA in state court practice. And we're real happy here to have Alicia Summers and Andy Yost here with us. I will turn it over to them and let them introduce themselves further and get started. Thank you.
Thank you. So my name is Alicia Summers. I am the Director of Research at the Capacity Building Center for Courts, and I've had the pleasure of doing work with the courts, the child welfare court systems for about 17 years now, including quite a bit of work around looking at ICWA compliance for different sites. And I'm very excited to be talking to you today about some of our findings from our ICWA Baseline Measures study that we did, collected data on back in 2018. And I will let my colleague introduce himself and then we will jump in.
Hi, everyone. I'm Andrew Yost. I've worked with a number of you. It's nice to see your names, at least again. I'm an attorney with the Capacity Building Center for Courts. I work with my colleague, obviously, Dr. Alicia Summers. I do a number of things. I'm the co-lead on the Tribal Court Improvement Program, grantee support. I'm a Region 8 liaison. I do a bunch of stuff. One of the things that I do is, or at least I'm boning up on, is my ability to do this kind of research. So while Dr. Summers was certainly the lead and the expert on these findings, I added the legal perspective and some sweat equity in terms of doing data collection and working with the site. So structurally, in the way that we'll present today is Dr. Summers, given her expertise in social science research, will sort of lead us through the substantive the method and the substance of our findings. And then I'll poke in along the way and ask questions that we know sort of emerged through our own research and through various presentations like this one. At the same time, I would just reiterate what Laura has already said, which is feel free to use the Q&A pod liberally. I'll keep an eye on it. If I'm not asking the right questions or making the right comments, put them in there, and then Dr. Summers and I will take them up.
Great. So let's go ahead and jump into our topic today. We're very excited to be able to share our findings and our research with you all, and we'd love to hear from you. So keep the questions coming. If I say something that you'd like more information about, feel free to send us some questions. We're happy to discuss this at length and also happy to answer any of your questions. My goal anytime I do research is to make it useful to the field. So that's what I'd like to try to do here as we walk through the process. So just to give you a little bit of background on the study, we did this work primarily in 2018. At least that's when our data collection efforts occurred. We really wanted to do something related to focusing on how states implement ICWA, and with a focus on better understanding what are the parts in the process that looks like. So some of those things that you would traditionally consider more ICWA compliance type measures. looking at how they're implementing ICWA into practice, what that looks like, but also looking at cases following through all the way to outcome to really get a sense not only of what practice looks like, which is our preliminary question, but also how is that related to case outcomes. As far as I know, this is the first undertaking of its kind and might be the only undertaking of its kind where we've really tried to focus in on if states apply ICWA in a meaningful way and they're following the things that they're supposed to do, does that lead to better outcomes for children in the system? So we were really excited to be able to do this. We offered this as an opportunity to court improvement programs all over the country and took basically first come, first serve in terms of who would like to do this until we run out of resources to collect data. The data collection was very intensive. We ended up with 5 sites across 3 states, and they're listed here on the slide for you. All of these sites, if I'm not mistaken, now have ICWA courts where they focus specifically on ICWA cases. At the time of our data collection, because we were looking at recently closed cases so that we could look at outcomes, our sample did not in every site include cases that had been through an ICWA court. Most of the courts were relatively new. So this primarily served as baseline, with the exception being Duluth, whose ICWA court had been in place for several years. So we worked with these 5 sites to gather data. We collected data between February and August of 2018. And part of our process was we were looking at cases that had recently closed, a sample of those cases. We also did a little bit of court observation just to get a general sense of what practice looked like in ICWA cases. And we had 2 purposes for this assessment. One, we wanted to give something back to each site. So we gave them all an individual report that says, this is what your data looks like. So these are your numbers. These are your findings specifically for this project. And then we also wanted to do a multi-site comparison. So at an individual level, we're collecting a small number of cases from each site to give them just to be able to describe what their practice looks like. But if you add all of those sites together, now we have enough data to look at it and make some comparisons in a broader way. So then we wanted to do a multi-site comparison. And for that, we're looking at what does application look like across sites and how is that related to outcomes on these cases. So as part of our process, we first had to identify what are the main things that we want to measure as part of an ICWA case. We held a series of focus groups with professionals from the field, travel members, attorneys, judges, social workers, a lot of legal professionals in the field, and had some conversations around what are the main things that we need to measure. And then we prioritized that list based on 1, what's measurable, and 2, what's easy to measure, and what do folks think are most important. So we tried to narrow it in from there. The reality is there's a lot of things we'd like to measure. They're a lot more resource intensive than some of the easier things that we measured through a structured case file review. So we had to make some decisions based on our available methodologies. And for the study, that was primarily a structured case file review. So we went on site and we looked at closed cases, and mostly that meant they brought us big carts full of files, paper files for us to wade through to figure out what had happened on these cases. We did a little bit of court observation as well in the sites that had hearings. We'd come on site and do court observation. That was primarily just to get a general sense of what practice looked like. Those hearings weren't related to the files, because all those cases were closed and did not have active current hearings related to them. So we did that on site, and then we came back and we combined all that data into one data set for analysis. Each county that we worked with got their own data in a report, and then we combined everybody else into this and did some statistical analysis. So later on, I'm going to prepare you now so you have time for the non-data people for your eyes to stop glazing over. We did 2 types of analysis. Most of our analysis are what we call descriptive analysis. So we're just describing what practice looks like. We'll give you percentages or averages for most of the data. But then we wanted to look at whether or not ICWA application predicts a better outcome. And for those, we did a couple different types of analyses. One, we looked at correlations. That's just relationships between two variables and whether we saw that or not. And for the other, we did predictive models using regression. And I'm not going to go into the detail here, but for anything that we talk about when we say predictors, we found a statistically significant impact of our item on an outcome. And all that means is mathematically, it's not happening by chance. There's something going on here. So we're really excited to be able to do those. We presented our findings in the terms of both a report and to individual sites and one larger report that's going to include everything we're going to talk about today. A couple things to think about while we have really what I consider really exciting findings. The study did have some limitations. It was a fairly small sample size. I don't know how many of you have done case file review, but it is a relatively rigorous process of wading through a lot of paperwork, trying to pull out the information that you need for something like this. We don't have this type of data in a court case management system, so there's no administrative data that we could use to do this, and we had to go through court case files. So because of that and resources, we could be on site for a couple days and we would see what we could get. And that limited our sample size. So it's relatively small for statistical purposes. We did have, I believe, at least 50 for each site. So we had information that was usable information and it was random. So that was helpful. We did have some missing data. Some of the sites we worked with didn't always have orders on file. And sometimes you would get a reference to notice, but nothing that told you exactly when the notice was. So we've had some missing data as part of the study. That's fairly consistent when you're doing file review. Things don't always get filed as appropriate. And that also limited our ability to do some things. We also didn't look at hearing practice on these cases. So that was a limitation to the study. And then we had to identify the appropriate constructs to use. So if we're saying these are the important things to measure, we had to figure out how we were going to measure those. Consider something like placement preferences. You could say, are they in a preferred placement, yes or no? But that's a little tricky considering they might not be with a relative. They might be in foster care, but there's been a finding that they couldn't place somewhere else. So what we did was we put placement on a sliding scale from the most preferred to the least. And that's how things got scored when we were doing something like that. So we had to figure out how we're going to score everything as part of the process. And that can be done differently is why it's a limitation. That's a brand new thing that we did to look at this. And so there's other ways to look at it. Our sample had 272 cases that we reviewed in those 6 months in 2018. Those included cases from Colorado, Minnesota, and Montana. The problem with this, and I'm sure some of you have run into this problem, it's not always easy to know when it's an ICWA case. Even systems like Minnesota's court case management system that have a flag saying this is an ICWA case, there are some challenges because it might get flagged early in the case because it could be an ICWA case. And then later in the case, it doesn't get unflagged when they find out it's not an ICWA case. And then some systems don't have any flags to help us know whether it's ICWA. So we had to pull a lot of cases, and sometimes they wouldn't find out till late in the case that it was an ICWA case. So we ended up with 272 cases, but of those, you can see 92 were not ICWA cases. They turned out to be not ICWA. In 26, we never got a finding for sure that it was an ICWA case. And in 154, they were confirmed ICWA. So we had some limitations with our data. For the most of the analysis, we really focused on those confirmed ICWA cases to really get a sense of what that looked like. Some of them, when we're talking about how long it takes to make a finding, confirming or not, or saying it's not an ICWA case, we'll have all the hearings in there or all the cases in there. But for the most part, this 154 is our number of interest here. These are the things that we looked at for the study. So when we were talking about ICWA application, we looked at notice. So when it was provided and when it was received, if that data was found. We looked at time to confirmation of ICWA status. And what we mean is at what point, they might get a petition filed that says this is an ICWA case. At what point did they make a finding that this is an ICWA case and have supporting evidence? So membership information or a letter from the tribe? Did they actually confirm ICWA status on a case? Some of these started out as this might be an ICWA case, and we had to wait and see. So we looked at how long that took from petition filing. We looked at the findings on the record. Is there an active effort finding, and where is that in the process? Is there any evidence that there was use of a qualified expert witness for testimony? Was there a finding of serious emotional or physical damage to the child if the child was removed from the home? Where was the child placed? Is there a tribal representative present at the hearing? And then were the parties present, and did they have attorneys, and were there attorneys present? So we looked at all of these. I know someone asked in their pre-session inquiry whether we accounted for appeals. We did not look at appeals as part of this study, only the information in the file. And because the appeals process only happens in a sample of hearings, we wouldn't have had enough data to really focus on it unless we only focus on an appeals process. So we did not track information on appeals as part of this study. All right, so now to the good stuff. I'm going to give you a general sense of what our data looked like before we get into the predictors. And for me, the predictors are the fun part of the data. So really figuring out like what's related to what. So we have the sites listed on here, site 1 through 5. They're de-identified in our report. That was something we agreed on with the sites. They get their own report of data, but when we share it publicly, we do not identify sites. We want them to feel comfortable being involved in the research study and have an opportunity to get their data, reflect on it, and use it in a meaningful way without someone else using their data. So we just have them listed as sites 1 through 5 to show you some of the variation that we saw in practice. So in terms of notice, about 93% of the cases said they provided notice to the tribe of filing. So that was typically pretty good. It took really different amounts of time depending on the sites. Clearly, some sites had processes in place and relationships with the tribes to be able to move this forward quicker. It did take about an average of 17 days, but you can see from the graph on the left, there was wide variation ranging from 1 day on average to 76 days on average to do that. The return receipt took a little longer. So the average of 17 days is a court document that says notice was sent. And for the return receipt, you can see there's a big difference here. We only had 42 cases where there was documentation in the file of a return receipt. And when we had that, it took much longer than those 17 days. It averaged almost 2 months for notice. And that was one of the challenges, is documentation of this process. We also looked at how long it took for the courts to confirm that this is, in fact, an ICWA case. A lot of our courts would treat it as an ICWA case if there was reason to know, but we wanted to know how long this is actually taking. You can see from this, we had a huge range. Some of them, like that, immediately it came in, they had information. So on the first day, it was confirmed ICWA case, a range up to 1,252 days. So taking multiple years to confirm as a case, but the median was 34 days. So for the most part, within 30 days, there was a confirmation. And again, you can see there was a huge discrepancy between sites from the graph on the left of how long that took. It varies widely based on practice in the jurisdictions.
Hey, Dr. Summers, quick question. Can you, just on one of your preceding slides, you were talking about making the ICWA determination itself. Can you talk a little bit about how we made that determination from a data perspective?
Absolutely. So what we looked for was the court making an order with supporting documentation. So if they had a checkbox that says this might be an ICWA case, we did not count that. We needed an actual finding on the record that ICWA does or does not apply. And we wanted that to have like the supporting information, and it could have come in the petition where they're filing the petition and they say this is an ICWA case and here's why, and that was sufficient. Or if they don't know, if the social worker says this might be an ICWA case and we're outreaching to the tribe, that was after we got the confirmation from the tribe, and the orders came in from the court. So when the letter came in from the tribe that confirmed it was ICWA, we would count that earliest of the dates, either that or when the court made the finding after they received the letter.
Got it. So you can see one implication from that is that you could theoretically cast a much broader net. If someone in the room, for example, was wanting to build on this research, you know, the know or reason to know standard that we use in ICWA to determine whether for example, whether or not we should apply active efforts and so on, or apply the ICWA protections, would include a much broader number of cases in children than we looked at in our particular study. So that's just one, I think that's one important thing to think about if you're a state or a tribe or a jurisdiction interested in building on some of this research. So we had a much narrower definition of what counted as an ICWA case than you might have on a legal standard.
And I see another question related to that. So did we find that cases where there were reason to know, where the court did not find ICWA applied until receiving confirmation from the tribe? That's a good question. And we did not look at that. We have to go back and look. We had kind of an ICWA pending as an option for the finding at the early hearings, like it might be ICWA, and that's how they would phrase that at the beginning. And then we looked later, but I don't know if we really focused on the reason to know specifically in that way that we could answer that with our data. But I'm happy to go back into it and see if that's something we can explore. So the other things we looked at are active efforts. So we did use the descriptors of active efforts from the BIA guidelines around this and tried to, this is super hard to do because it's very qualitative in nature and it has some subjectivity. So we did look, did the court make an active efforts finding? And then at which hearings did the court make an active efforts finding? And for this, it had to say active efforts. It couldn't say anything else. We required the language to be very specific around our findings. And this was a yes or no finding of, did the court make a finding of active efforts? But that's different from, did the agency make active efforts? So we tracked both of those, but primarily we looked at the finding because the majority of the time they're making the finding that they did make active efforts on these cases. And then we tracked what those active efforts were if they were described, especially if they were described by the court. And we had an opportunity to look at that. Sometimes we had to interpret how those efforts would align with these categories that we had created. And we had an opportunity to write in additional information as well as part of these. And you don't have site level data here because one of the interesting things we tried to look at is which hearings are we saying this finding at the most often within the case? You can see from this, we did have quite a bit of more than we'd seen of other things of active efforts findings. It was most likely to occur at the review hearing. And then secondary to that was at the plea or adjudication hearing early in the case, where they're making a determination regarding whether the court has jurisdiction. So we saw active efforts findings there. It did vary widely between sites, but 74% of the hearings had an active efforts finding of just the ICWA cases, and 85% of the cases had at least one active efforts finding across the life of the case. So it might not be at every hearing, but they had at least one across the life of the case. But we did not see the courts describing the active efforts that often. So only about a third of our cases did the court have any detail about what those efforts were. Most of the time they referenced the agency reports, which is what we relied on in determining what they were considering active efforts in the cases. And then we looked at the use of qualified expert witness testimony, and 47% of the cases, we found some evidence that there was qualified expert witness testimony. You can see we had a couple sites where we never saw evidence of this. In talking to some of the stakeholders, they implied that this was happening, but we didn't find it documented in their case files. And if you're doing file review, that's how you get the information. So if it's not documented in a way that we can find it, we counted it as 0. So we definitely had some variations here in how this is being used.
Dr. Summers, another question came in from Sandra. Thanks, Sandra. She asks, how are cultural needs being met or ordered in court? I'll just make one brief comment, and then Summers, I'll let you add whatever gloss you'd like. Our instrument didn't capture a ton of nuance or particularity with regard to like the specific cultural context for the kids and their tribal membership or their tribal heritage. So we don't have like what I would call maybe that third layer, right? That there were active efforts, that's the first layer, whether there were or not. The second layer for me is sort of, were they, did they have a cultural component to them? But then what was the nature of that component? We definitely didn't get that deep in the third piece. And I'm just speaking sort of anecdotally from my own, when I was doing the case file reviews, what I think I saw was that where it was court ordered, it was usually sort of like, you know, your standard list of here's the 5 things we did or 6 things we did. You know, we connected the parent to the tribal service or something like that. So unfortunately, we don't have a ton of nuance, but where it did show up, in other words, where in the court order there was a specific reference to the tribe or a culturally grounded service, we were able to catch that in that second layer of our, and where our instrument caught that second layer by checking the box. A little bit clunky, sorry about that. Summers, anything you want to add?
Yeah, I would say that how are the cultural needs being met was something that came up in our focus group as something that we'd like to measure, but not something that we could easily measure as part of the data collection methods that we'd identified. And so it wasn't something we were able to really collect information on. It's very more subjective and qualitative in nature for us to do. And so we tried to focus on the things that we could get really good reliability on for this first part of the assessment. We did put out kind of a list of these items that we think are important in our prioritize, I'm not sure why I can't say that today, our prioritized list for these. So we recognize it's important. It's just something we weren't able to do as part of the study. And when we did find the QEW testimony, it was typically around adjudication. So early in the case processing. We also looked at whether there was ever a finding only if the child was removed. So this was another subsample. So our sample keeps getting smaller and smaller. Cases removed from the home. Whether there was a finding that there was likely to result in serious emotional or physical damage to the child. And 2/3 of the cases had a finding somewhere that this was the case for when the child was removed. Again, this is numbers were driven down by one of our sites that we just didn't find orders that had all the information that we were looking for. So we didn't have consistent court orders and couldn't consistently tell from the minute orders what was happening in these cases. And then we looked at placement. And we looked at whether they were in a preferred placement at removal. And so this was on the continuum. These were the ones that were on the low end of the continuum. So more likely to be placed with a relative or an approved foster home. And most of them were in a couple sites. We had the majority placed with a relative or in a preferred placement. You can see we had other sites in the middle that was like closer to half or less than half. 31% had a finding related to placement preferences. So not only did we know where they were placed, but the court actually made a finding to the effect they were in a preferred placement. And 52%, so about half across all our samples, were in a preferred placement at the initial hearing. And 63% were in a preferred placement at the first review. So this varied kind of widely across sites. This is another one that can be sort of subjective in some ways in terms of we know where they fit on the scale, but it's hard sometimes to know if there's a more preferred placement that they should be in, unless they're talking about that in some way in the file, not in the hearing, and they might be talking about it in the hearing. And then we found tribal representatives were really present at several of our sites, often there from the very first hearing on a case, and in other sites they were less likely to occur. So on the graph here on your left, that was a tribal representative ever present at hearing. And we count present via phone. So if they were there in any way in the hearings, and you can see some of our sites were much less likely to do this than others. So at less than a quarter of our initial hearings had a tribal representative present, and 52% had never had a tribal representative present at any of the hearings across the life of the case. We did have a lot of attorneys for parents present, depending on the site. You can see this is always the case. We're much more likely to have an attorney for the mother present. A lot of times the attorneys for the fathers aren't appointed until the father shows up, or in some of the sites until the father is identified on these cases. And so depends on how practice varies of when they get them. So you can see we saw some variation in practice here around how often they're present, and the table up top shows you across our entire sample how often they were present across the life of the case. Okay, and finally, before we get into the fun stuff of what predicts what, we looked at case outcomes. So we looked at our sample, and then we compared this to the Adoption and Foster Care Analysis and Reporting System sample, which is not a one-to-one comparison because our kids were all ICWA kids, and we don't have a data variable about ICWA in the AFCARS data. So we could only look at American Indian children in care and compare that. And you can see in our sample, we had a higher rate of reunification and relative custody than we did in the larger sample for nationally in terms of kids and what their outcomes were on the cases. But we did have which this is higher than national right now as well in terms of reunification cases. All right.
Summers,
Yes.
a couple questions before we get into the findings here. I'll just read through them and then maybe you and I can kind of kick them around a little bit. So one of them is, was there anything indicating if the tribe received notice of the hearings, if that was why they weren't present? And that's, I think, related to another question regarding the tribal representative not being present. Was it that they were not invited or the tribal representative chose not to come? As I recall it, we didn't track reasons for non-appearance, only the fact of non-appearance. So we can't say one way or the other, but what we can say, as you'll see in a minute, is that the presence of a tribal representative, especially early on in the case, has an impact on outcomes.
You totally stole my thunder. That's my favorite finding. No, we did not track reasons they were not there. We did track, however, whether notice was provided to the tribe prior to that hearing, or actually more accurately, whether we found an indication that notice was provided, because that was some of the data that was much harder to find within the case files.
Got it. Thanks, Summers. And another one, in terms of the increased protections under 1912, did we look specifically at whether the heightened evidentiary standards of clear and convincing for foster care placement beyond a reasonable doubt were expressly used? We did look to see whether or not the clear and convincing standard was used in the court order. So where it was, you got credit for that. But I don't think we did. We did TPRs. Okay.
We did beyond a reasonable doubt for termination cases, but you can see from our numbers here, we only had 12% that were adopted on this. And so our sample of TPR cases is very small. And that is why we do not have data describing those. The sites got their data if they had for their cases, but for the most part, we didn't have enough to really look at that in terms of a predictor.
Got it. Thanks. And then one last question. Do you have tribes taking jurisdiction after a year into the case? If so, what process is taken? Well, Summers, any comments on how we accounted for transfer?
We couldn't tell an outcome. The outcome ended up on ours as transfer to the tribe, which it made up about 5% of the cases that we had that happened later in the case. And we know when it occurred relative to the case opening as part of our study, but we didn't do much with those because, again, our number was really small and we can't tell what the outcome was for the youth in terms of it's now in a different location and it doesn't have the state court requirements related to ICWA. And our focus was really on what the courts there were doing. And so we didn't follow those cases any further. Okay,
thanks, Summers. You can let the thunder roll now.
Okay, this is the fun part for me was what were our predictors of some of these outcomes? So what in our list of the ICWA application factors did we find that was related to outcomes? And I will say for every one of these, we looked at every single factor. So we looked at all the ones we listed earlier. We looked at notice, we looked at active efforts findings, whether the tribal representative was present, whether they were in a preferred placement, all of those we considered as application of ICWA. And so from that, we created a construct. So what we did was, if they had an active efforts finding that was kind of in compliance, so that's a 1. And if they were in a preferred placement, that was more on a sliding scale. And if it was on the low end of that in the bottom quartile, they got a 1 for application. So more in compliance. And we basically summed up all those in compliance type measures and came up with an average application construct. And what that says is how well did they do across all of these different items? And overall, they didn't do too bad. They definitely have a lot to work on. But we had this average construct that helped us really conceptualize ICWA applicability across all the items. And then we looked at the items individually. So those that were applying ICWA more in general also were more likely to have the child in a preferred placement. When there was a mother and father present more often across the life of the case, those cases, the kid was more likely to be in a preferred placement. And when they had an attorney for the parents, those kids were more likely to be in preferred placements than the cases that did not. So we saw some big relationships here to being in a preferred placement. The presence of the parents in the case is always a huge predictor for us of better outcomes for the families. So that's not a big shock for us.
Summers,
Yes.
sorry to interrupt. Are the adoption cases, do we have any information on whether or not the adoption cases fell within the ICWA adoption placement preferences? In other words, were the adoptive placements consistent with the placement preferences, or do we track that at all?
You know, I can't remember. Hold on.
I can't remember either. That's why I'm asking.
I can't remember if we tracked that. We knew whether they were in a preferred placement up through the permanency hearing because we tracked that at every hearing where the child was placed. But I don't think we looked at, no, we did not look at what the final adoption looked like on our cases in terms of whether that ended up being with a preferred placement or not.
Got it. Thanks.
We looked at what predicts reunification. So this was where we found some really exciting things. Mom's presence throughout the life of the case predicts reunification. In almost every study I've ever done and looked at this, that's been the case. But we also found that the sites that were more likely to apply ICWA across all those different dimensions also had higher rates of reunification. And then we found some relationships to specific active efforts, but I would interpret those with caution because we had a lot of challenges with the active efforts categorization, and that data is not as good as I would like it to be. Another thing that we found that was super interesting for us is if a tribal representative was present at the very first hearing on the case, then there was an enhanced ICWA application, which means they had somebody there at the beginning, then they were more likely to apply all components of ICWA across the life of the case. And those cases were more likely to result in reunification. We saw something similar related to that with time to permanency. I know, sorry. There we go. Time to permanency or time, no, not time to permanency, I'm sorry. Time to returning home for the reunification cases. If there was a tribal representative present at the first hearing on the case, those cases got home quicker than other cases. And if the court was able to confirm ICWA status earlier in the case, those cases got home quicker. So moving that process and having these pieces in place was super important to predict returning home. We also looked at factors that predicted timely permanency. If a tribal representative was present at the hearings, then the was timely or permanency. If they were shorter in confirming it was an ICWA case, more likely to result in timely permanency. And the placement at the first hearing really mattered. If they followed preferred placements earlier in the case, if that was further down on the continuum saying compliance with that, those cases also got home quicker. We did find something interesting related to the active efforts finding at the initial hearing. If the court made an active efforts finding at the first hearing, that the cases took longer to achieve permanency. We don't have an excellent explanation for that, other than a lot of our courts have boilerplate language around reasonable and active efforts where they just make a finding. And so whether to the extent that that was meaningful and useful, we're not sure what was going on with that. And then the final thing we really looked at was which things were predictors of actually applying ICWA. So if they made a finding, if the court makes the finding at the first hearing that ICWA does or does not apply, clearly, does for these cases, they were more likely to apply ICWA across the life of the case. That also meant if they made that finding then, that there was more likely to be a tribal representative present across the life of the case. So they would show up more often if they're finding out early. If there was a tribal representative present across the life of the case, that was a relationship to other application of ICWA findings. So they're more likely to do other things if they also have the tribal representative present there. The longer time it took to get notice to the tribes, the less likely they were to implement ICWA fully. And then we found mom and dad's attorneys. If they're showing up at the cases, then they're more likely to apply ICWA. So they seem to be a positive resource for the families to ensure that ICWA got implemented within the jurisdictions. So I'm going to pause there. We have some consideration questions, but I would really just open it up to you guys in terms of what your big questions are. I'm curious if there are things from here that you find interesting, or if you see things from our study that could be useful and implications for your own practice and the courts you work with.
In that vein, one thing that came up in the Q&A here, Dr. Summers, is Juanita's observation or question. She says, what about a measure of active efforts to prevent removal and breakup of the Indian family? I think that's one of those really, really ripe opportunities. There's actually a lot of them that I would say flow from the findings that we have here. My colleague Sheldon Spotted Elk, with whom I've worked for years, with whom I've worked over the years on this material, is making a lot of really strong suggestions that are practical, things that you can do almost starting tomorrow to improve the likelihood of ICWA application and the outcomes that we've just discussed in this presentation. What I like about Juanita's question is it's sort of like the next, it's one of the things that we can do next. So it would be wonderful to do a research project, in my opinion, on the role of active efforts as a prevention mechanism, right? Preventing the removal and the breakup of the Indian family. That was not included, that sort of specificity was not included in our study, but that's sort of the 201 type of research that we would love to engage in, and we'd love to see the field engage in. So here's my one promo. If you're interested in that, reach out to myself or Dr. Summers, because we can help you conceptualize what that research is, and who knows what the future holds, maybe participate in it in some way. But we're both very passionate about moving this work forward and discovering more so that we can inform and improve practice going forward.
And to that end, we'd love to hear from you on things you'd still like to know about this. As Andy said, like, this is something we're very interested in. We need more research in the field. There's a lot of questions we don't have answered. This is just kind of a preliminary, first attempt at this type of work. We'd love to expand on it. So part of that is for us figuring out what are the big unanswered questions that we can help contribute to.
So a couple questions, Summers. I'm not sure if you can see them. I'll just read them out so that folks can. One is, do you think that the presence of an ICWA representative influenced outcomes, or more like the agencies with better outcomes and placements were more likely to ensure a representative was present?
Yeah, the reality is it's impossible to tell from data like this. The tribal rep being present at the first hearing having a positive influence across the life of the case. That wasn't a jurisdiction level finding, it was case specific. So I do think for those, we can say that that came first, them being there, but the reality is the ones where there's a tribal representative at the very first hearing on the case already have a different culture in their court and have a better relationship with the tribes to encourage that. So it's really hard to tell. Mostly we can just show relationship and we can't pinpoint these specifics for this study.
Good, thanks. I see a couple here. Joey in the Q&A and then Juliana in the chat. So I'll take these two summaries and then maybe I'll pass the other ones on to you. Joey, was urban versus non-urban Indian families factored in the variables of the study? The answer is no. But that, again, much like Juanita's comment, it was a really, really rich opportunity for additional research, right? That we all know that the urban versus non-urban distinction can have a huge impact on sort of the nature of the case itself. So would be a place to dig into. Juliana asked what research bodies approved the research. So this was approved by the Children's Bureau, and the research was conducted through Dr. Summers' leadership by the Capacity Building Center for Courts.
We also went through an institutional IRB, and I believe at the time it was the National Council of Juvenile and Family Court Judges, IRB, because that's where I was working at the time.
And do you remember how long it took to get approval and conduct the research?
So getting approval for studies like this that don't collect data that identify people, they're exempt most of the time from IRB research if you're not collecting personal information. So for file review and court observation, our instruments don't collect that level of data. So it takes less than a month to get IRB approval through an institutional board. To do that, to conduct the actual research takes longer. It depends largely on the site and the site's resources to coordinate efforts like this. You know, we did 5 sites across 6 months to go in and collect the data. And then it took a little bit longer to do all the fun data cleaning and analysis and reporting to get their report out. So I think we spent about a year start to finish on this project while we were, of course, also doing multiple other things.
Got it. Thanks. And I see that Sheldon posted a link to the Pima County ICWA court evaluation. So some of these questions might be in the chat's gotten flooded related to that. So if we're doubling up, apologize for that, but I still think that's a really germane question. So a few others. First of all, Maria suggests that we consider New Mexico for our next study. So noted, Maria, for sure. Holly says, can we get anything outlining what's required to comply with ICWA? I'm working on reviews to see if we're complying, but I'm not sure exactly what is required. Well, we can certainly share with you our research instruments, our data collection instruments themselves, although I would not read those as a comprehensive list of everything that's required by ICWA, right? That's going to be, there's a lot of evaluation decision, or I should say research decisions that we made in constructing that instrument. So it's by no means comprehensive, but it'll at least give you, it's something, right? It's some kind of reference that you could use. Summers, anything you want to add there?
No, I think that's a good place. I mean, there's a lot of information about the regulations and what that looks like, but we're happy to share the tools so you can see the pieces that we collected.
Yeah, and I'm seeing in the chat a lot of people endorsing this idea of research around active efforts and getting into that what we're calling the next sort of third layer of not only the active efforts, but which active efforts and the effect that they can have on preventing removal and reunification and so on. So I'm with you on that. For me personally, if there was a place to dig in, that would probably be it.
And these courts, most of them were not ICWA courts. They're ICWA courts now, but only one of them had a fully implemented ICWA court that was represented within the data we collected. The others had new ICWA courts, and we collected data looking back before those courts had really been implemented into practice. So we're hoping that the data can be used for those courts as baseline information to see how practice changes over time.
What other questions do folks have? Catherine, I see your comment in the Q&A pod. Thanks for that.
Yeah, that is an excellent question because everybody asked me that and I have zero data on it. I have no information on frequency of hearings, no information on frequency of court reviews, because some folks ask if we do more frequent court reviews, is that related to better outcomes? And the reality is that we just don't know in the field. We get a lot of folks saying that they see it works well in their courts, but I don't have any data or research to support it, although I get asked all the time. It is definitely on my list of things I'd like to be able to answer for the courts.
Yeah, and to Ken's point, by the way, for those of you that are members of the judiciary, I apologize for using your first names. I just don't know one way or the other. So as an attorney, I'm imagining me saying Your Honor if you're a judge. Yeah, to Ken's point here, you're right. I mean, this idea, the definition of foster care placement in the statute raises additional questions about when the protections are triggered. So that is another sort of next layer of analysis and research that could be done. I appreciate your point there. And I think Catherine has made it as well. So thank you for that.
That is a good question. So the question is, do we have information on whether or not they're getting QEW if parents stipulate in these cases? Hold on a second. I'm looking to see what we tracked on our form, because if we tracked stipulation, we also tracked QEW, and we could look at that correlation, but I'm not sure if we did, in part because we tried to limit our data collection around this so that we weren't collecting extra things so we could get through more cases quicker, because it's a fairly lengthy tool anyway to just look at the things that we did. And we did not look at whether there was a stipulation for the parents. So we didn't look at whether they stipulated to the evidence. And so we cannot look at that, but I think it's a great idea.
Yeah, number of you guys, this is a super active group and I appreciate that. So if I missed something that's you've said, I apologize. But one person in the chat says, could this study be replicated in another state?
Yes. Yes, and the report is publicly available, and all the instruments we used and our methodology are described in there. But what's more, we're happy to help folks if they want to do something like this. We are happy to help others do it. We would love to do some more work in this area. Again, like expanding this to see if we find similar things, but also working with these same courts to see if practice has changed and how that's impacted on outcomes.
Yeah, so with that in mind, I know we're coming close to the clock here. I would reiterate that. So Juliana, yes, there is a paper that we have, a published paper of the findings that we can share with everyone. We'll make sure that that gets out along with Summers. Do you mind sharing the PowerPoint? We can do that, right? Yeah, okay. Sharing the PowerPoint. The instrument is in the report itself, Sarah, so you'll be able to pull it out there and use it. And then let me just reiterate what Dr. Summers said. She and I both have an interest in continuing this research. So if you're sitting there thinking, boy, I'd love to build on this, but I don't know how to get started. The way that you start is you can shoot Dr. Summers and or I and CC the other an email, and we can start to explore with you what that might look like.
Right, I think.
Thank you so much for that. I was glued to my seat. I learned so much. I want to thank everyone for attending today, and we will follow up with an email. And Laura put in the chat a link to an evaluation that we'd like you to fill out. And stay tuned. Remember our next webinar, this is first in a series of 3. Part 2 is called What Now? New Lessons Learned in Tribal State Partnerships. And that's Wednesday, March 23rd from 3 to 4:30 Eastern Time. And we're excited. We'll have folks from 3 sites, Oklahoma, North Dakota, and Minnesota, that received ICWA implementation grants from ACF. So don't forget to register for that. And the third one, which will be on March 29th from 3 to 4 Eastern. And that is a closer look at active efforts and the ICWA Family Preservation Program in North Dakota. So hope to see you again.
Thank you, everybody.